Good afternoon, everybody. Thank you for having me, Jonathan. I'm going to speak today on assent, the concept of assent to contracts as it applies to consumer contracts. And the materials are up on the screen. I didn't do fancy PowerPoints, and don't try to read because I've decided to, based on watching everybody else, to cut to the chase and talk about the area I think is the most interesting, to me at least, and one that maybe fits good in a 15-minute slot, and that is assent when you're talking about incorporation by reference of other documents. And I'll start a little bit and talk about how I got into this area of the law. And the dispute most commonly comes up when you file a lawsuit in a consumer transaction, and the other side says, but wait, there's an arbitration agreement. And so the question then becomes, and we litigated these questions, and as to whether or not the arbitration agreements were enforceable. And there's a whole series of decisions. I think they were up to Brown 6 by the time Borders firm finished with it on the issue of whether or not an arbitration agreement was enforceable. So I had a case, and I started thinking and looking at the facts of the case, and I said, wait a minute. Instead of talking about whether something is procedurally unconscionable or substantively unconscionable, let's talk about whether or not the consumer agreed to it. And so there was born the U-Haul case. And Floyd's in the back of the room. Floyd remembers the case well. And Floyd was on the other side of that case while the litigation I'm talking about was all going on. And let me just talk a little bit about the facts of what happened in U-Haul. U-Haul, they rent trailers and trucks. Commonly, the customer walks into the U-Haul store. The U-Haul, they have these little electronic terminals, and the little electronic terminals, the sales rep has you go through, click whether you want insurance, do all these things. And I won't talk about the substantive part of the case, but at the very end, there's a box where you have to sign with a little electronic pen that says, I agree to the terms of this rental contract and the rental contract addendum. You sign on the little electronic box. The customer service person then prints off a form. It's a one-page form. It has the substantive terms of your rental agreement, how much you're paying per day, charges per mile, whether you got insurance, all of those other things. And at the bottom, there is a signature line where they electronically capture your signature from the box and put it on that form. The person then folds that piece of paper up, sticks it in a little colored contract document holder, which has advertisements on it. They try to sell you storage things, moving help, tells you what to do if we break down. And in the middle of that document is an arbitration clause. And so those were essentially the facts of U-Haul. And I said, faced with those facts, I said, wait a minute, we can talk about whether that's an unconscionable contract under the Brown standard, but instead, I don't think that is something that anybody's ever agreed to. So we litigated that case, get to the Supreme Court, and the Supreme Court says, yeah, you're right. And what the court held is that under the law of contracts, and there's a lot of interesting discussion in that agreement, or in that opinion, about different kinds of electronic contracts and these newfangled contracts, shrink wrap agreements, browse wrap agreements, click wrap agreements, and all that. But in the end, they say, all of these fancy agreements still have to comply with regular old first-year contracts law. You have to agree to the terms. And they've cited, the court looked at its law on incorporation by reference and said, yes, incorporation by reference is a possibility. And what that means is one contract incorporates another contract into the document. So the argument is, does this rental contract that you signed electronically incorporate this rental contract addendum? That was the question. And the court says, yes, you can generally do that. However, the court set some restrictions. First, they said that a general reference in one writing to another document is not sufficient to incorporate that other document into a final agreement. Can't just generally refer. And then they looked at a lot of cases, other places, and came up with a three-part test. Under this three-part test, you have to have a writing must make a clear reference to the other document, so the party's assent to the reference is unmistakable. That's the first requirement. The second requirement is the writing must describe the other document in such terms that its identity may be ascertained beyond doubt. And then third requirement is it must be certain that the parties to the agreement had knowledge of and assented to and incorporated the document so that the incorporation will not result in surprise or hardship. Sounds like a good test. In that case, applying that, they looked at the agreement. They said, well, there's a reference. We'll give them that. But it's not the kind of reference that calls to the consumer's attention the idea that there is a contract, this contractual language. Then the third thing, the fact they found, quote, troubling, was that the language was not given to the consumer until after they signed the contract. So that's the U-Haul test. Now, since U-Haul, there have been a number of cases applying that test or similar tests, and I sort of want to talk about those, because I think it's important if you're litigating these kinds of cases as to whether or not it's set. And it doesn't just happen in arbitration. I mean, I've got cases where there is a limitation of liability clause in a contract, which says you're limited to a certain amount of damages, where there are all kinds of nasty provisions in these other documents that consumers don't see until well after the transaction, if ever. The other example is limits on statute of limitation, limits on who can sue, what duties you have standing, forum limits. You've got to file lawsuits in, Upper Idaho, in federal court there. So all these are the kinds of provisions that consumers that are, I would say, are anti-consumer, or at least anti-consumer protection litigation for consumers, and that the kinds of things that can show up in these contracts. So they're important to be able to challenge them. And it's hard to, and I think unconscionability is a hard challenge. Is the other alternative. And the court especially with arbitration, as the U.S. Supreme Court has become more willing to summarily overrule state Supreme Courts that don't uphold arbitration agreements on the merits, our courts have been more reluctant to find arbitration agreements not enforceable. However, the one thing the court has stuck with is the idea that you have to agree with it. And it's the interesting thing in the oral argument for the West Virginia Supreme Court, Justice Ketchum told me, he said if we rule in your favor, the U.S. Supreme Court is just going to reverse us. And of course, Justice Davis said, I've never been reversed by the U.S. Supreme Court. She wrote the U-Haul opinion. They took a cert petition, and cert was denied. So these kind of basic contract formation theories are important. So I want to talk about three cases that have come out since U-Haul. One is Evans v. P.L.L.C, and that was a brokerage agreement contract. And let's talk about the facts in that one. In that case, the court recognized that the incorporation by reference was valid. In that case, the arbitration provisions were set forth in the brokerage agreement that was incorporated by reference into a signed application. Same thing. You sign the application, and somewhere in the document is a statement that says, by agreeing to open this account, you agree to this brokerage agreement that is in another document. Now, in that case, the application not only referenced the arbitration clause in the brokerage agreement. So not only did they say you agree to the terms of this agreement, say, by the way, that agreement has an arbitration clause. And it explicitly said, and if you're looking for the arbitration clause, it's on page 6, told you where you could even find it. The application also included an acknowledgement that the customer received and read the contract that was incorporated by reference. And in that case, there was actual testimony by the broker that the arbitration clause was explained. So that on those facts, the court applied the U-Haul test and said, yeah, okay, that you identified the document, you told the customer where in the document you could find it, and actually even called it to his attention orally. So it's fair to incorporate that document and the arbitration clause in the court, the compelled arbitration. Next case, slightly different facts, is G&G Builders Inc. versus Lawson, 2016 case. In that case, there was a 12-page architect's contract. In that, and in that provision was interpreted another form contract. In that other form contract was the arbitration clause. These general conditions with the arbitration clause were not attached nor provided to the customer. There was no provision in the agreement requiring the customer to acknowledge they had received, read, or agreed to the conditions. There was no allegation that the general conditions were brought to the customer's attention, and the customer explicitly said, I didn't see this, I didn't know anything about it. And lastly, the word arbitration didn't appear anywhere in the agreement that the customer signed. So the court said, and this was an opinion written by Justice Lawfrey. And one of the other points is, interesting thing about these decisions is these aren't 3-2 decisions. These are all 4-1-5-0 decisions, but going both ways. So I'm not sure the law is really clear how it applies, but when the court gets them, they either go one way or another pretty clearly. And the last case I want to talk about in terms of this incorporation is Navient Solutions versus Robinette. This is a memorandum decision for 2015, and this was a student loan application. And and it's a memorandum decision, and we can all debate as to whether or not whether those are good decisions or not good decisions. There's still precedent, and this is what the court decided. That case, you have the application for the loan, which incorporates a note. The note has the arbitration clause in it. And what the court found in that case is that it was one document. Now, all this stuff was filled out online, and what the allegation was by the consumer was that these were 2 documents, and I only signed the first one that doesn't have the arbitration clause. But in that case, the document that was signed had an express acknowledgement that the terms and conditions set forth in the promissory note constituted the entire agreement. So the agreement we signed said, hey, we are incorporating the promissory note. There was also the statement that says, from the borrower, that I have read and agreed to the terms of the promissory note accompanying this application, read and agreed. And then there was also, but there was no testimony that the promissory note was called to the borrower's attention or that arbitration was mentioned in the agreement. So a little bit different than, it's sort of in between the other 2 cases where the court went one way versus the other. In this case, the court found that it was incorporated and called it to their attention. Now, the last case is really not an incorporation by reference case, and it's a case where the contract was being modified. And it almost seems like, if you read these decisions, that the court's applying a looser standard in enforcing these other documents when you already have a contractual relationship and you're modifying it. In that case, it's Citizens Telecommunications versus Sheridan. And in that case, it's the phone company. The phone company, with respect to its internet services contract, sent out notices in their billing statements. Hey, we're changing the terms and conditions to your agreement. And by the way, there's an arbitration clause. In that case, on page 4 of the billing statement, there was notice that modification was happening, and it was going to be effective in 45 days. The billing statement referred customers to the website where the terms and conditions could be accessed online. One of the billing statements actually included the terms and conditions, but the customers again argued they hadn't read them. They're difficult to find on the website, and that they weren't actually on the bill, in the first page of the bill. The idea is being that these consumers, nobody ever looks at anything other than the first page of the bill. Now, I tried to synthesize all these together to come up with a rule about what the court's doing, and I confess I can't come up with a clear one. It did in the student loan case. The documents were there in the it doesn't appear to be determinative that whether the other documents actually had the other documents, although the court doesn't like this document somewhere else. But there's lots of different facts that apply in these cases. And I think to argue these cases, what you have to do is very clearly get down to how the transaction happens and explain to the court. In the cases where the court has found that these agreements are incorporated, they seem to say, look, it was explained, this is where you could find it. And if you're drafting these things, there's lots of helpful language in these opinions on what gets enforced. But in the cases where it's more haphazard, then I think that it's less likely to be enforced. And last thing I want to say, I already got to wrap up, but I'm going to talk for maybe 1.5, 2 more minutes. The end of the story on U-Haul is after going through years of litigation over the arbitration clause and then years of litigation over class certification, sometime in the middle of that, U-Haul changed their contract. You would think that they would have changed it and put a lot of other things like in these other cases, but they made one change. On the piece of paper that gets printed out and handed to you, it says, oh, by the way, you agree to an arbitration clause. This piece of paper that you don't see until after it's electronically signed. And so the court certified the class. Judge Tabbitt has ordered class notice to get out. Maybe some of you might be class members. But what we did is we bifurcated the class, and we have what we call the new contract subclass. And we're going to litigate a motion to compel arbitration as to whether or not that one change in the document is enough to change the result in U-Haul. Now, we also have some new justices that might change the result too, but I believe that's not enough. It still doesn't meet the U-Haul test, but I suspect in 6 or 8, 10 months we'll find the answer to that question out.